Hi, I am Rajesh. I am a practicing company secretary. In this series of videos on drafting, pleading and appearances, let us see what is a delegated legislation and what is the concept of separation of power. If you have not yet subscribed to our channel, kindly subscribe to our channel, and if you like the video, kindly press the like button and also share it with your friends. Now, before we start with what is delegated legislation, first we will have to understand what is an act. Now, we know that the act is formulated or it is framed by the legislature. That is, once it is passed by the Lok Sabha, now let us assume that it is a central piece of legislation, then it will have to be passed by the Lok Sabha, and then it will have to be passed by the Rajya Sabha, then it will go to the President, and once the assent of the President is given, we call it as an act. Until we receive the assent of the President, it is called as a bill. So, here we will have to understand this concept of separation of power. Separation, that is, each person is supposed to do only his part of the work. For that, we have the legislature which will make the law, and then the judiciary which will interpret the law, and then the executive which will execute the law. Now, the judiciary is not supposed to execute the law, and then the executive is not supposed to interpret the law. Similarly, the legislature is neither supposed to execute the law or else to interpret the law. So, each person will have to do their own work. Now, this week, if one person enters into the arena of another person, or else one body enters into another body, then that we call it as usurping the jurisdiction of another person, which is not permitted under the Constitution. Now, first the act, that is, once a bill is placed before the Parliament, assuming that it is a central piece of legislation, it is placed before the Parliament, that is, it could be a Lok Sabha or else it could be a Rajya Sabha, and once it is passed by either of the houses, like let us assume that it is passed by the Lok Sabha, and then it will go to the Rajya Sabha, and then it will go to the President. Once the assent of the President is given, then we call it as an act. So, it means naturally that whenever an act will have to come into force, it is presumed or it is understood that both the Lok Sabha and the Rajya Sabha will have to be in session. That is, the members of the Parliament will have to sit, and then they will have to discuss the pros and cons of each piece of legislation, and then they will have to decide whether they will proceed it with making an act or else not. Now, for each passing of an act, it naturally presumes that we need time. That is, the time of the members of the Parliament is required, and naturally their energy is required. And for any small changes, it means that we will have to go back to the Parliament. Now, this is not a feasible thing, because every time you cannot ask the members of the Parliament to come and sit. Maybe there is some sort of emergent situation where it is not possible for the session of the Parliament to sit. Then naturally what happens is you cannot bring about that piece of amendment. So, what they do is they give you the skeleton, that is, the legislature will give the skeleton, and then it will allow the executive to fill the flesh and the blood into the skeleton. So, that we call it as a delegated legislation. The legislation is being done by the legislature, but it will delegate certain portions of its power to the executive, and that portion we call it as a delegated legislation. Now, for example, let us see what is the definition of a small company. Small company, which is given under the Companies Act of 2013, it says small company means a company other than a public company, and it speaks about the paid up share capital and then the turnover. It says the paid up share capital which should not be more than 50 lakh rupees, which should not exceed 50 lakh rupees, or such a year amount as may be prescribed, which should not be more than 10 crores, I mean with the recent amendment. And then the turnover should not be more than 2 crore rupees, or such a year amount as may be prescribed, which should not be more than 100 crores. I am talking like after the amendment is made. Previously it was 2 crore rupees for the capital, and 5 crores for the capital and 20 crores for the turnover. Now, there they say which should not be more than the 50 lakh rupees or such higher sum as may be prescribed. So, whenever we look at the term as may be prescribed, it means that the legislature has given that power to the executive. To what extent they have given? Now, let us take only the capital portion. They say that it cannot be more than 50 lakh rupees or such a sum as may be prescribed, which should not be more than 10 crore rupees. So, if at all it is more than 10 crores, it means that they will have to come back to the legislature. Now, let us assume as of today, that is 2021, The executive feels that the capital for a small company, if it is 50 lakh rupees, I mean, if it is 1 crore rupees, let us assume that it is a small company. After 5 years or 2 years, they may feel that 1 crore rupees is a very small sum. They would like to increase it to 2 crores. Then they can increase it to 2 crore by framing certain rules and regulations. Then after a couple of years, like maybe after 5 or 6 years, they feel that they need to increase that 2 crore rupees to something like 5 crore rupees. Then they can increase it. Now let us assume they want to increase it to 10 crore rupees. In the previous act, that is when prior to the amendment, it was 50 lakh rupees and 5 crore rupees. Before the amendment, if at all the executive felt that it should be more than 5 crores, that is even if the capital is more than 5 crores, we will still consider it to be a small company. Naturally, it had to be placed before the parliament, and then we required the approval of the Lok Sabha, Rajya Sabha, and then the assent of the president. Only after that it could have been done. But now what they have done, they have given the power up to 10 crore rupees or turnover of up to 100 crore rupees to the executive. So they don't have to go back to the parliament. They don't have to place it before the Lok Sabha or else the Rajya Sabha. They don't have to take the assent of the president. The executive simply will have to pass certain rules and then say that from today, even if the capital of a company is 6 crore rupees, 7 crore rupees, it will still be considered to be a small company. So this portion or this thing is called as the delegated legislation. So once a piece of law is passed by the parliament, it could be a Lok Sabha, Rajya Sabha, and the assent is given by the president, or in case of the state, it could be the assembly and then the legislative council, and then it will go to the governor. If it happens to be a state legislation, then that we call it as an act. So whenever we see the term act, it means that it has been passed by the legislature and the assent of the president or the governor, as the case may be, has been given to it. And whenever we see the term rules or regulations or notifications, circulars, it means that those things have been passed by the executive. If a piece of law is passed by the executive, you don't call it as an act, you merely call it as a rule, or else you merely call it as a regulation, or else a circular, or else a notification. Now this is called as the delegated legislation. Now if at all there is some sort of doubt in the let us assume a portion of law, then what do? You take it to the judiciary. The judiciary will interpret and then say whether the law is constitutionally valid or else constitutionally invalid, or a particular piece of legislation or else a particular section you have got some sort of ambiguity. Then you take it to the court of law and then they will say whether there is ambiguity or the person who is actually interpreting is not interpreting it in the right manner. So what the legislature will do is the legislature will make the law and then the executive will execute the law, and then the judiciary will interpret the law and then give the judgments based on such interpretations. Now this concept is called as delegated legislation. Now we have this concept of substantive law and then the procedural law. Now what is a substantive law? A substantive law is that law which gives you the rights, liabilities, duties, responsibilities, etc. It tells you what you are supposed to do and what you are not supposed to do. And how you are supposed to do it and how you are not supposed to do it is given under the procedural law. Like for example, 4 board meetings will have to be conducted in a year. This is a substantive law. And how you have to conduct those 4 board meetings, or when you are supposed to conduct those 4 board meetings, that is the gap between the 2 board meetings, it should not be more than 120 days, and you will have to comply with the secretarial standards which are issued by the ICSI. Those things we call it as a procedural law. So when you actually look at the company law, it is a combination of both the substantive law as well as the procedural law. So once if a person has to know the law in toto, then he will have to understand both the substantive law as well as the procedural law, because only with the procedural law we will be able to appear before the tribunal, that is how to make appearances or what are the forms that needs to be filed. Like for example, the act says that you are supposed to file a particular form. It says a particular form before the registrar of companies within 30 days from the date of holding of the annual general meeting. Now what is that particular form, or what that particular form is called, that is given under the rules. We call it as AOC 4. The act says you will have to file a particular form within a period of 60 days after the conducting of annual general meeting. Now what that particular form is? That particular form is form number MGT 7. So they merely say what has to be filed, they merely say a particular form has to be filed, but the procedural law says what is that particular form, what are the details that will have to be given in that particular form. So it is like I want to write a letter to the ROC. Writing a letter to the ROC is like the substantive law. What I am supposed to write, how I am supposed to write, in what manner I am supposed to present it is given under the procedural law. Now once you are able to understand this concept of delegated legislation and the separation of power, then you will be able to understand that why it is required and the importance of having this concept of delegated legislation, because every time the parliament cannot sit and every time we cannot waste the time of the parliament, it is required that the power is given to somebody else, because most of the time when they sit in the parliament, more than the discussion there are arguments, they throw chairs at each other and the time is wasted, and then there is an adjournment. Sometimes there is an adjournment without mentioning the date. So what do? They say that no boss, we cannot do it. So what you do, you take the power, but you don't take the entire power from us. We will say the limit within which you are supposed to act, within that limit you can act, and that is called as the delegated legislation. In simple terms, we say that the skeleton is given by the legislature and the flesh and the blood will have to be filled by the executive. If you want to learn more about the subject drafting, pleading and appearances, kindly fill the Google form given in the description box below. If you have got any comments or questions, kindly leave it in the comment section below. For more courses from Ekcel Academy, kindly visit excelacademy.com.